Hey everyone, good morning. I see we've got a few people who've joined already. I'm going to give it just another minute or two since we're right at 9, just to let a few other people jump on, and then we will get started. All right, we will go ahead and get started. People are still jumping on, but good morning again. I'm Amy Jordan Wilkes. I'm a partner in the Labor and Employment Group in Burr's Birmingham office, and I'm joined by my associate Gabriell Jeffries, also in the L&E group and in the Birmingham office. But we wanted to just do a short kind of refresher on the Pregnant Workers Fairness Act this morning. We're getting close to when we think the final regs are going to come out, and we thought it was a good time to kind of remind everyone that yes, this act still exists and still something you have to comply with, and just kind of make sure that it's top of mind before these regs drop really any day now. So I wanted to start with, how did we get here? How did the Pregnant Workers Fairness Act come about, and what exactly is it for anyone who does not know?
So we wanted to talk just a little bit about the background, just generally what it is. So the Pregnant Workers Fairness Act was passed to fill in gaps left by existing statutes like the ADA, the Pregnancy Discrimination Act, Title VII, and the FMLA. So under these previous statutes, under the ADA, for example, routine, uncomplicated pregnancies were not considered a disability requiring accommodation on their own. Now, there could be, circumstances where complications or something could lead to an ADA qualifying disability, but routine pregnancy was not generally a disability under the ADA. So in addition to that, we also had the Pregnancy Discrimination, which all this one did was it prohibits discrimination against pregnant employees, but it just doesn't have an accommodation requirement as part of it. Now, there was, you couldn't treat pregnant workers differently than similarly situated non-pregnant workers who may be provided accommodations, but the Pregnancy Discrimination Act itself did not have an accommodation requirement. And then kind of the third statute, that kind of played into this world was the FMLA, of course, but which, requires leave, but it has these eligibility requirements that end up, excluding a lot of workers. It's based on hours worked, how long you've been with the company, the number of employees that you as an employer have within a certain distance, and things like that. So there was kind of a gap there for, say, maybe an employee who, had only been with the company a couple months. There was no, FMLA obligations there. So that's kind of how we ended up here with the Pregnant Workers Fairness Act. And so what does the Pregnant Workers Fairness Act do? Well, you see on the slide there, it requires covered employers to provide reasonable accommodations for a worker's known limitations related to pregnancy, childbirth, or related medical conditions. Of course, unless that accommodation would cause the employer an undue hardship.
And just a refresher, and we'll talk about this, what do we mean by undue hardship? It's significant difficulty or expense. So it's not just, a little bit burdensome. It's got to be, unduly burdensome and undue hardship. So here's kind of the timeline of where, how we got to this point. PWFA signed into law in December of 2022. It went into effect in June of 2023, and the EEOC started accepting charges then. We do know that the EEOC is already, investigating and looking into these charges. Not aware, after doing a quick search yesterday, of any actual lawsuits that have been filed yet. They haven't been able to make it through that EEOC process, which we all know can take a long time. So we don't have any lawsuits yet, certainly don't have any published decisions on it, which makes all of this a little bit of a gray area still, since we don't have that guidance from court. But charges are being filed. This is, something plaintiffs' lawyers are paying attention to. I think we're only going to see that go up. So June, charges can be filed. August, the proposed regulations came out. The EEOC was required to get final regs out by December 29th. So they have sent those to the Office of Information and Regulatory Affairs that reviews all regs. That office has 90 days to review the regs for, how expensive they're going to be and how it impacts other agencies. They can get an extension if they want to, and we don't have any way of knowing if they have, but anyway, 90 days from December 27th when the EEOC submitted those. That's how we know those regs are probably going to come out soon. So it's interesting with the comments. The EEOC says they received over 100,000 public comments on the regs. And I don't know if any of you have ever gone to look at the comments on regs. Some of them are from, businesses and law firms and interest groups, and some of them are just, everyday citizens who just, want to tell the EEOC something or give you their thoughts on federal agencies. So, that does sound like a significant number, and the EEOC will go through those. We don't really have any way of knowing if they make any changes to the regs based on the comments or not. Sometimes they do, sometimes they don't. So that kind of remains to be seen. So that's where we are. We're still in a waiting game with the final regs, and we still don't know what those final regs are going to say. But the proposed regs are, a good idea of what the EEOC thinks the rules should be and how they think the law should be interpreted. So that's, always a good place to start.
Right. So even though we don't have those final regs, there's a lot of information that has been provided in those proposed regs. So we kind of wanted to go over some of that. And in particular, we know that the accommodation requirement, in the context that a lot of you have dealt with that before, is under the ADA. So we wanted to talk about, things, kind of interesting nuances from the Pregnant Workers Fairness Act proposed regulations that make it different from the ADA. So we've kind of identified 5 big differences between those two that we want to go over. So the first one is, who is entitled to an accommodation? So just the basics of it is the Pregnant Workers Fairness Act is much broader than the ADA as far as who is entitled to an accommodation. So under the ADA, it would have only, in the context of pregnancy anyways, it would have been only pregnancy-related conditions that cause a physical or mental impairment that substantially limits a major life activity qualify as a disability that must be accommodated. Under the Pregnant Workers Fairness Act, these pregnancy-related medical conditions don't have to rise to the level of an ADA-covered disability. Conditions under the Pregnant Workers Fairness Act can be minor, modest, episodic, and still be covered. So this is, we talked a little bit about the kind of gaps in the coverage of the existing laws before. This is one of those. It's designed to cover even, uncomplicated, healthy, par for the course pregnancies. So as far as what the, what the statute says about what it's covering, it is identified, 3 areas. Those are pregnancy. And now the important thing to know with pregnancy itself is it is not just the current pregnancy. It is the current pregnancy, but it also could be a past pregnancy or potential or intended pregnancy. So we want to emphasize that, this doesn't only apply to people who are currently pregnant, have not given birth. It could be before or after as well. So it's very broad in that context. The second one, of course, is childbirth. That one's probably the most self-explanatory, labor, delivery, all of that. And then finally, the last part of it is related medical conditions. So, when you read that, you probably, like me, were like, well, what is a pregnancy-related medical condition? So the definition that we've been provided is medical conditions that relate to, are affected by, or arise out of pregnancy or childbirth as applied to the specific employee or applicant in question. And so that's a pretty broad definition there.
Yeah. So you can see on all these boxes, I mean, we've got everything from nausea to carpal tunnel syndrome to dehydration. And these are not conditions that Gabrielle and I just made up that we thought might be pregnancy related. These are actually listed in the regs of conditions, excuse me, that the EEOC think were pregnancy related conditions. And some of these I think are very not obvious. And I don't think just in the, day-to-day world of the workplace, that your HR people and supervisors are going to think that the use of birth control is something that requires accommodation. But according to the EEOC, it does. So, obviously this is really going to broaden the scope of people who might be seeking some sort of accommodation. And I think the other thing that's important to mention, in addition to everything that's listed here and everything that might potentially fall into this universe, pre-existing conditions that an employee or applicant has that have been exacerbated by pregnancy or childbirth might also qualify under the PWFA. We think this list, when actually litigated in the courts, will probably be cut down. I think there's a good chance when you really have to go through all of these things that the courts say, nah. Dehydration is not something that needs to be specifically accommodated, but that remains to be seen. We're still, as I said, in a waiting game. So I think this is one of the most interesting and dangerous parts of the PWFA.
Another thing to point out is how the proposed reg itself reads is it's not just this specific list, these are examples, and it specifically says including but not limited to. So in the EEOC view, this is not even the entire universe. It could be potentially even more expansive.
That's a great point.
So the next big difference that we wanted to talk about is who is a qualified individual, and the difference between how that's defined under the ADA and now the Pregnant Workers Fairness Act. So with the ADA, as many of you know, the employees have to be able to perform the essential functions of their job with or without accommodation to be a qualified individual. It doesn't matter. They have to be able to perform the essential functions of the job. Pregnant Workers Fairness Act, this is where it really differs from the ADA. So under the Pregnant Workers Fairness Act, we have an employer applicant who, with or without reasonable accommodation, can perform the essential functions of the employment position. Additionally, an employer applicant shall be considered qualified if they cannot perform one or more of the essential functions. If that inability to perform an essential function is for a temporary period, the essential function could be performed in the near future, and the inability to perform the essential function can be reasonably accommodated. So what does that mean? It essentially means that, under the Pregnant Workers Fairness Act, you can still be a qualified individual entitled to accommodation, even if there is a period of time that you cannot perform the essential functions of your position. So this is very different from the ADA. And so you're probably wondering, what is that temporary period? Where do we go from there? And so, we have that the essential function could be performed in the near future. Well, what is the near future? So the proposed regs have given us some insight into that, at least what they, proposed defining it as. So the proposed regs have defined in the near future as 40 weeks from the start of the temporary suspension of the essential function. And that's generally 40 weeks. So it could presumably be even longer than that. And the other interesting part of this is that it's also not just, during the pregnancy. They're also proposing that it could restart that 40 weeks once the pregnancy is over and the employee comes back to work. And then it's 40 weeks seems to be kind of the number that they landed on, but the EEOC at least appears to have been considering longer time periods as well, because they were seeking comments on whether that period should even be 52 weeks. So that could potentially be a very long time that an individual is unable to perform the essential functions of the job, but would still be entitled to an accommodation.
Yeah, and we'll talk about this some at the end, but these parts of the regs, I think, are where a lot of the training is going to be so important, because it's not something that you would think of. I think, there's a real risk that your, on the floor supervisor is not going to realize that, employee X had the baby, came back to work, but oh no, she still has an issue that needs to be accommodated for months potentially. So I really think that's an area that's going to have to be emphasized, and one that I don't think people realize or really have been paying attention to, just because we haven't got to the point where there's kind of high profile litigation on this, but it's definitely coming. Okay, so the next kind of big difference between the PWFA and the ADA is how we handle requests for accommodation. So the slide here, under the PWFA, it is an unlawful employment practice for the employer to require an employee to accept an accommodation other than any reasonable accommodation arrived at through the interactive process. So to request an accommodation, all the employee applicant or even a representative of the employer applicant needs to do, they just need to communicate that they have a limitation and they need an adjustment or change at work. Really simple. Under the ADA, I think, we have a lot of people have very defined process. They have forms that need to be filled out. There's a lot of times back and forth with the employee's doctor where you're asking for more information. You're really focusing on essential functions, and it's not going to be that formal under the PWFA. Generally, under the ADA, you do not have to provide an employee with the accommodation of their choice. And you don't have to, if there are multiple reasonable accommodations, you don't have to offer them in any particular order. While that's still technically true under the PWFA, the EEOC does say that the primary consideration is to be given to the employee's preferred accommodation. So that's, something to keep in mind, and a bit of a change. So I think what's interesting under the regs is, they give a lot of examples of what would be a reasonable accommodation. And we didn't list them all on a slide, but some of them are frequent breaks, standing, sitting, scheduled changes, telework, reserve parking, light duty, job restructuring, modifying uniforms, things like that. But they also list 4 specific accommodations that they call predictable assessments. And they say in virtually all cases, these are reasonable accommodations that would not impose an undue hardship. So what those 4 are allowing an employee to carry water and drink as needed in the employee's work area, allowing an employee additional restroom breaks, allowing an employee whose work requires standing to sit and whose work requires sitting to stand, and also allowing an employee breaks as needed to eat and drink. So if an employee comes to you and they request one of those 4 things, the EEOC is basically telling you that your individualized assessment of that accommodation should be simple and straightforward, which is code for you should just allow them to do it, or we're going to say that it's failure to accommodate and an unlawful employment practice. The EEOC also says that given the temporary nature of a lot of pregnancy-related issues, that employers should respond quickly to any request for accommodation. And they should consider granting it on an interim basis, even if you think you need additional information. So that, I think, is also a change. Sometimes with the ADA accommodation, if it's not obvious, like I said, you're going to have that back and forth with a doctor where the employee is going and getting more information about what it is they need and why they need it. So that's something to keep in mind with the PWFA.
So with this request for accommodation, we really wanted to emphasize that, kind of how they've laid it out here is a pretty low bar for what constitutes a request for accommodation, just this limitation and the need for an adjustment or change at work. So we wanted to go over some examples of what that may look like. And these examples are pulled, we didn't just make these up. They are pulled directly from the proposed regulations. So this is what the EEOC is providing as examples of requests for accommodation. And now there's several of those in there, but we've pulled ones that we feel like are likely to come up quite frequently that might not ordinarily be recognized as a request for accommodation. So our first example we have here is a pregnant employee tells her supervisor, I'm having trouble getting to work at my scheduled starting time because of morning sickness. So, pretty innocuous comment there, just, hey, I'm going to be late, I've been sick, I'm pregnant, that sort of thing. So what do we think about that? Request for accommodation or no? Well, here's what the EEOC has to say about it. It says, breaking this down here, morning sickness is a physical condition related to pregnancy that impedes a person's ability to eat and drink and requires access to a bathroom. So they've identified a limitation, and it's related to pregnancy. And then they've also identified a change needed at work. So a change in the work schedule. They're saying I'm having trouble getting to work at my scheduled starting time. So this is a request for a reasonable accommodation under the Pregnant Workers Fairness Act. So we just wanted to emphasize, how easy this one sentence here, I'm having trouble getting to work at my scheduled starting time because of morning sickness. That is a request for accommodation that, triggers these obligations for the employer.
Yeah, and I have heard of specific charges that have been filed over morning sickness, particularly in the food service industry, where people are making food, cooking food, serving food, having a hard time being around it. That is one that has thus far come up frequently in the early EEOC charge filings.
And it makes sense, morning sickness is a pretty common symptom, that people often experience early on or even throughout their pregnancy. So this is one that we really wanted to identify because it's likely to come up.
Yep. All right, example number 2. An employee who gave birth 3 months ago tells the person who assigns her work at the employment agency, I need an hour off once a week for treatments to help with my back problem that started during my pregnancy. So is that going to be a request for an accommodation? Well, yes, it is. Because the back problem, it's a physical condition related to the pregnancy, and the employee has identified a change needed at work. They need leave for their appointment. That's a request for reasonable accommodation under the PWFA. And the reason we highlighted this one, it's what we talked about earlier. This is an employee who is no longer pregnant, who is still needing an accommodation because of a condition that was exacerbated or started during the pregnancy. I think, absent the PWFA, that this absolutely would not be accommodated. And I still think that thinking is prevalent, particularly with frontline supervisors who would not realize this is a request for accommodation when they received it.
Right. And so we're going into our third example. We have an employee verbally informs a manager of her need for more frequent bathroom breaks, explains that the breaks are needed because the employee is pregnant, but does not complete the employer's online form for requesting accommodation. So in this example, the employer's clearly got some sort of process in place. They've got a form they want employees to fill out for their request for accommodation. This employee doesn't do that. He just, mentions to her manager, hey, I need more frequent bathroom breaks. So what do we think with this one? Yes, we also have this as a request for accommodation. So the need for more frequent bathroom breaks is a physical condition related to pregnancy. The employee has identified a change that she needs at work. That is, the additional bathroom breaks. And the important thing to remember with this one, what we wanted to highlight is that the employee doesn't have to use any specific words or your specific form or template to make a request for accommodation. a lot of times we see employers who they've done all the groundwork. They've got these processes in place. They have their forms, the process is there. They want people to use it. And that is great. That's what we want. But the important thing to recognize is that they don't have to do just that. The form is not the end all be all. It doesn't turn on whether the employee filled out the form or not. Is the form helpful? Yes, certainly. But also these verbal, even kind of offhand comments just to, maybe their manager or their supervisor, also are requests for accommodation. Even if you have this process in place and they didn't, go through that process and fill out the form.
Yeah, and the last thing I want to say about accommodations is if you can provide a partial reasonable accommodation under the PWFA, then you still must provide the accommodation up until the point that it creates an undue hardship. And, the example that the EEOC gives is perhaps there's an essential function that you can eliminate for a few weeks. Fine, someone's at the end of their pregnancy, they need to sit down for the last couple of weeks. That's an accommodation that you should provide. Where if you had to allow that employee to sit, even though this honestly is not that great of an example because the sitting is a accommodation that the EEOC says you should always grant, but I'm going to go with it anyway. But providing that accommodation for 6 months, that would be an undue hardship. So you really got to focus on that individualized assessment of what the employee's job duties are and how the accommodation would affect them, and whether it really would affect your business in a significant way or not. It's not a bright line rule. It's not a yes or no. You also, the regs caution that you can't argue undue hardship based on an assumption that if we allow Jane to do this, well, then everyone else is going to ask for the same accommodation. And then if everybody does it, we really can't do that. That's not good enough for the EEOC to establish undue hardship. So it goes back to that, case by case basis, individualized assessment for request.
And with the undue hardship analysis, that is, even under the ODA, that's a pretty high bar to meet. And another kind of factor that plays into that is, your business, the size of your business, the resources available to you, all of that kind of also goes into that analysis for how difficult it may be for you. So, another example of that is, if you're a very small business, just a couple employees, you may be able to allow the employee, a couple weeks of, an adjusted schedule or something like that, but a full 9 months might be more of an undue hardship on your business because, hey, you've only got, 5 employees. And so, that's a huge chunk of your workforce there. So that's another consideration as part of the undue hardship analysis.
Yeah, bottom line, that the things that you have always said, nope, this is an essential function. We can't, eliminate this. We can't accommodate requests like this. That needs to be rethought in the context of the PWFA. So the other difference we have with kind of how PWFA claims are handled versus ADA, I think as I mentioned earlier, a lot of ADA requests you get in kind of an exchange of documentation, you're getting doctor's notes and things like that. The PWFA limits your ability to obtain documentation. As a general rule, they caution, the EEOC does, that the employer should not seek documentation to establish that a employee or applicant is actually pregnant. That's not, you don't need to see the pregnancy test results. That's not something you want to be asking. Requests for documentation that violate the regs or the act could be considered unlawful retaliation or coercion. So when is requiring documentation not reasonable? And they give several examples, which we have listed on the screen. The first one is when the limitation and the need for the accommodation is obvious. And the employee confirms it and the need for an accommodation through attestation. That classic ADA example is, if someone's in a wheelchair and they ask you for an accommodation for their wheelchair, that's not something you need to send them to the doctor to provide. Same goes with this. If, it's obvious, the morning sickness, things like that, you don't need documentation from a healthcare provider on that. The second one is when they've already provided you enough information to substantiate that they have a limitation and they need a change. You can't keep requiring them to get more and more documentation. Once it's good enough, it's good enough, and anything further than that's going to be considered retaliation. If it's one of the 4 things I mentioned before, the predictable assessments, the drinking water, the things like that the EEOC has said are almost always reasonable. That's another time where you can't or should not make the employee get you medical documentation to support that they need to drink more water or they need frequent bathroom breaks at work. The last one is related to lactation and pumping, which we have not talked about in this presentation, but it's just another reminder that the other big law that was passed and recently is the Pump Act, which extends and expands on protection for women who are expressing breast milk at work. This kind of plays into that as well. Someone needs an accommodation for lactation or pumping. That's not something you need to send them to a doctor to get a note for.
Right, and we just also, it was in that list of potentially pregnancy-related conditions. That is a good thing to bring up, is that lactation and conditions potentially related to that also fall under this broad umbrella of, pregnancy-related conditions that require accommodations under the PWFA.
Yeah, and the big takeaway again, as we've been saying all morning, if it's not clear already, your normal process for handling accommodation requests under the ADA, the way you always did things with, your rules and your documents, that can get you into trouble into the PWFA.
Right. And then our final kind of difference that we wanted to talk about between the PWFA and the ADA is that there is no direct threat language in the PWFA like there was under the ADA. So under the ADA, an employer can refuse to provide an accommodation where it presents a direct threat to the health and safety of, the employee requesting it or, other employees around. So this language is not in the PWFA, but, that doesn't mean that it's completely out the window. Safety concerns are obviously a consideration into whether the accommodation is reasonable or, whether it may present an undue hardship. But we did want to point out that, that direct threat defense is not specifically delineated in the Pregnant Workers Fairness Act.
Yep. And the direct threat defense, even under the ADA, is extremely difficult to establish, particularly without specific evidence for the particular employee that they, are a direct threat to themselves or others. It's where we get into those no bright line rules, no generalizations. I think it's going to be, even harder to establish that with a lot of these pregnancy related conditions.
And we want to emphasize that, all of these considerations, you do need to undertake individualized assessments that are specific to the employee requesting it, and as well as what their job is. We don't need to have any of these sweeping sort of generalizations about, well, they're in this position, this is how we handle this, or, well, they've had this condition which has come up previously, because, circumstances, especially with conditions related to pregnancy, are very unique. So all of these accommodation kind of process analysis does need to be taken on a case-by-case basis.
All right, so we're in the waiting game, waiting for those final regs to drop. So what should you be doing now? What are kind of things you can do now to get ready? As always a good idea to review and update your policies. Everyone's favorite thing to do, but a lot of handbook policies that address reasonable accommodations are now going to be outdated. They're going to be ADA specific, and as we've just talked about for the last 30 minutes, there are a lot of differences between the PWFA and the ADA. So you need to look, dust off those handbooks, look at the policies, look at your procedures for requesting accommodations, and make sure those are compliant with what the law says and, what we think the regs are going to say. We don't want to be caught flat-footed and, be trying to scramble and do all this at the last minute. So it's a good idea to look at it now and think about what changes need to be made. The second thing, and I've talked about it a lot, is training your employees and not just HR. It's going to have to be your frontline supervisors to recognize requests for accommodation under the PWFA and recognize what conditions might be covered and the process that they need to follow for handling those requests. The EEOC emphasizes in the regs that employees should be able to obtain accommodations from the people who normally assign them their day-to-day tasks and the people they would normally go to with work concerns and issues. And that's going to be your frontline supervisors. And that is counter to what we almost preach every day, which is, you want to remove the supervisors from these leave and medical decisions. You want to take as much medical knowledge away from your supervisors as possible to avoid discrimination claims. And unfortunately, the PWFA is encouraging people, go to your supervisor, tell them all about your medical conditions and all the accommodations you need. So you're going to have to train them for how to handle it. And if handling it is you need to contact this person in HR, then that's how you handle it. But you don't want them to be caught unaware and not recognize a request for accommodation when they see it.
Right. This one is huge for me. I feel like we can't emphasize enough how important training is going to be for this act because, as we saw with some of those examples, I think one of the most important things, like Amy was saying, is just recognizing what constitutes a request for accommodation. Because we saw in the examples that can be just as simple as, hey, my morning sickness is causing me to be late. I'm struggling to get here and clock in on time. That could certainly be a comment that probably will be made to, these frontline supervisors. So being able to recognize that as a request for accommodation and knowing, who that person is to contact, what the next steps are, how to direct the employee is going to be huge.
Yeah. I mean, there are conditions that aren't covered that are now. But I think, the most important thing, as with any kind of leave accommodation request, always is the flexibility, no bright line rules. You've got to get away from this is how we've always done it. And, I know consistency is key in employment law. But in this case, we've got to look at everything individually. And the same confidentiality, the last thing I'll say, the same kind of confidentiality rules are going to apply to this as apply to ADA. You still want to remind your supervisor and your HR people that, we need to keep these requests and medical information, confidential in a separate file from the personnel file. So the last thing, stay up to date. So Burr Informant is going to keep you up to date when those final regs come out. We will be on top of that. And of course, we'll be pushing out client alerts and probably have another webinar. But in addition to just looking for information from us on those final regs, we talk to you guys every day about, issues. We talk to you guys frequently. When you're talking to one of us about, Title VII issue, just be like, hey, have you heard anything about the PWFA? What, we don't, confidentially, we won't use names or anything, but we don't have, problem, kind of telling you what we've heard, what other people are seeing, kind of what the legal landscape is, what charges we've heard are being filed. Those are good ways to get information about the scope of the law and kind of what the landscape is, outside of our formal client alerts and these webinars. So don't hesitate to shoot us an email or give us a call and just be like, hey, what's new with the PWFA? What are you hearing? What are you seeing? So
Right.
I don't see any questions in my box. Gabrielle, do you have anything else?
I do not. I'm not seeing any either. We just kind of wanted to go over again as the charges may be coming in, as people are having more questions, there's more familiarity with this law. And as any day we're expecting those, final regulations to be published, we just wanted to go back over this and highlight what we think are going to be key areas moving forward.
I do have one question. It says, how does FMLA apply to this? I mean, FMLA is still FMLA, right? That's a job protection statute. The PWFA doesn't expand who FMLA applies to. What it does say about leave is that you cannot force an employee to take leave as a reasonable accommodation. And that's the overlap. But I think the simple answer to your question is, leave always is available as accommodation, but you can't force an employee to take it. But there's no amendment or expansion of FMLA under the PWFA. You still got to meet to be entitled to FMLA, you still have to meet all the criteria for, hours worked and number of employees and serious health condition and all of that, or, leave to pregnancy, childbirth, birth of a child, that adoption, all of those things are still the same.
Right. And there's certainly some interaction between the two, because as I was saying kind of at the beginning of this, the Pregnant Workers Fairness Act filled in some of those gaps that FMLA may have left. So what are those? To be eligible for FMLA, obviously you have to have, you worked for a year and 1,250 hours. So this entitles employees who may not meet those requirements to an accommodation. It also applies in, say, we may have an employee who has exhausted their FMLA leave for whatever reason, could be something completely different. They had to care for their family member or whatnot. And so, I think sometimes there's a tendency to think, well, they've used all their FMLA, there's nothing else available. Well, you would still, assuming it's qualifying, you would still have an obligation under the Pregnant Workers Fairness Act to engage in that accommodation process, even if this employee has already exhausted their FMLA. Right.
And we're not saying that you have to give the leave. That, again, would be that individualized assessment, whether it would be an undue hardship, but it's something you've got to consider. I don't